Thank you so much. I'm so glad to be here with all of you today. Thanks for sticking around to the Ethics Hour at the end of the day. I think I usually bookend all meetings. I'm either first or last most of the meetings that I come to. What I wanted to do today, I know I had been asked to come and talk about technology and media issues, and I want to get to that, but I also, in preparing this presentation for today, I wanted to touch on a couple of other things as well. So I divided this essentially into thirds. One third, who we are and what we do, which I'll go through relatively quickly, but I want to make sure that you all understand what our role is in the Office of Professional Regulation. And then the second third is a little bit about how to avoid seeing me professionally and how to avoid ethics complaints. And that's something that I feel really strongly about, and I think it's worth, I've actually made it kind of the center of all of my presentations for this year. And I think it's worth that time, and I want to get out to as many groups as possible and share what I've been able to glean from now about, I think I'm coming up on about 1,800 complaints that I've received and reviewed. So there's a lot of information that I've been able to extract from those that I think is helpful for you in thinking about how not to encounter my office as a respondent. And then finally, I want to touch on the media and social media and technology issues that I was actually asked to come talk about. So we'll go straight into this. Just for those of you who are not familiar with our office, we are a commission, a board of the Iowa Supreme Court. We're created by court rule. We don't belong to the State Bar Association, which is why my office is not in this building. My office is up the hill in the Judicial Branch building. Our Supreme Court supervises the professional activities of all lawyers in this state, and that's because the State Bar Association is not mandatory for every practitioner in our state. Some states have mandatory membership in their State Bar Association, and those State Bar Associations can regulate attorneys, but in our state, because this is not a mandatory membership organization, our Supreme Court manages the regulation of lawyers. We have about 9,600 active Iowa lawyers. That number may get updated a little bit as everybody finishes up their filings this season. I know we have just a few more attorneys who probably still need to get those CLE and client security reports in. Remember, the deadline for that is the 10th of March, so get that done. We are governed, all of us as practitioners, by the Iowa Rules of Professional Conduct. They were adopted by our Supreme Court in 2005. They're largely modeled on the American Bar Association's model Rules of Professional Conduct. And so we are able to use those model rules in other states where the language is essentially the same as ours as persuasive authority for our court in disciplinary cases. Our disciplinary system is set up like a second trial court system and appellate court system. It's a little bit of a shadow extra court system here in Iowa. So my office, the Attorney Disciplinary Board, is the prosecutor's office. We are just like any county prosecutor. We receive complaints about lawyers, we investigate them, we make determinations about how they should proceed based on the evidence and the information that's available to us, and then we may decide that a complaint contains serious enough allegations and we have enough proof, we believe, of those allegations that the matter should be prosecuted. If the matter is prosecuted, then it goes to our trial court, which is the Grievance Commission. And the Grievance Commission sits in panels of 5. They hear the cases basically as the trial court. They then issue, at the end of those hearings, they issue a recommendation, basically findings of fact and some conclusions of law, and a recommendation for disciplinary sanction, and that's then reviewed de novo by the Supreme Court. So all public discipline here in Iowa comes directly from the Supreme Court in the form of an order. There's a little bit of a different procedure for public reprimands than for suspensions, but essentially everything works its way through a vertical system, much like the court system that you're all familiar with. Last year, I've got some numbers that I think are maybe helpful for you in understanding the scope of what we deal with in our office. We opened 328 investigations. We closed just about 400 investigations. The board took action on slightly more than that, and that's because some of those board dispositions require further action by our staff in order to finish the case up. We've also started tracking inquiries from the public. That's something that we had never done before, but I'm trying to capture what it is that frustrates the public, our clients, and other consumers about interactions with lawyers. And so we're trying to track that information and make that information available to the court so that they can understand a little bit more about our interactions with potential complainants, even if we don't open an investigation. And I'm granted discretion under court rule to decline to open an investigation. I do that pretty regularly. So you'll see last year I declined to open 441 potential complaints. Those are complaints about which the subject lawyer never heard. So if I received a complaint about you and it was something that didn't merit investigation for whatever reason, you would not have been notified of it. Sometimes you'll know about it because your client probably sent you a copy, but you would not get any sort of formal notice from our office because we're not opening a formal investigation. And that happens sometimes because somebody's complaining that their criminal defense attorney was ineffective, or they're complaining that their lawyer went on vacation and they don't think lawyers should ever take vacations. Or they're complaining about something that we simply can't help them with. Maybe it's something that would be better heard on appeal, or it might be something that is more of a malpractice issue. The board generally takes the position, and I think this is consistent with what our court has said, that an isolated instance of error or even of neglect, but an isolated type of thing, is not necessarily disciplinary. And so sometimes we'll decline to open something if a lawyer just kind of flubbed up. Maybe made a mistake that a client could have a malpractice claim for, but not something that we think is necessarily disciplinary in nature. One of the things that I'm really proud of with respect to the work that we're doing right now at the board is we're finally getting ahead of our backlog. There were a number of years where we were opening more complaints than we were closing, and that was creating a backlog, and that is unacceptable for a number of reasons, not least of which is that it's really scary to have a disciplinary complaint open and pending against you. And so I want those to get done as fast as possible. So we're trying very hard to get ahead of that. And so the bars at the right, and you don't have to get into the details of them, but the bars at the right will make it clear that we are closing more than we're opening. That has continued into this year, and I expect it to continue going forward into the future. So one of the assurances that I can give to all of you is if you deal with a disciplinary complaint, we are doing everything we can to move it along more quickly than we've done in the past. So we've got some additional staff in place. My predecessor, Charlie Harrington, and his predecessor, Norm Bastemeyer, both do some investigations for us and provide case summaries, and then we have 2 full-time investigators. So we're working hard to get those processed and dealt with quickly. And the reason for that, let me kind of move on to this next slide here. The reason for that is that most of the complaints that we deal with end in a dismissal. So you should get your dismissal as soon as possible. This is just another way of looking at some of those data. Last year we closed 397 files, down the third from the bottom line there, and that represented 303 respondents. So what that should tell you is that periodically we get multiple complaints about a single respondent. That isn't probably surprising to any of you. Sometimes we have attorneys whose professional lives are kind of out of control, and so it's not unusual for us to get multiple complaints about the same lawyer. Some of those are twofers, some of those are 3, 4, 5, 6 complaints. And if things get to the point where we think that we need to step in and ask the court to impose some sort of temporary suspension of that lawyer's license because the lawyer's usually personal life is affecting their professional life in such a way that they're potentially a danger to clients, then we'll do that. But if you think about 9,600 active practitioners, 303 respondents, that's not very many. And actually that's a number that I'm really pleased to see. I think that that reflects a high level of practice skill here in our state. I think we have really good lawyers who are working really hard to be in compliance with the rules. So I think that's just a great number. As far as dispositions, like I said, most complaints that are reviewed and processed in our office result in a dismissal. So last year it was 61% of the final dispositions that happened. Those were dismissals. The next highest percentage is the percentage of private admonitions, and the board sometimes decides that there has been a violation of the rules, but it's not sufficiently severe or worrisome that the attorney needs to be publicly sanctioned. And so private admonition is a way for the board to say, yeah, you messed up, don't do it again. You know, kind of points out the violation and makes it clear that that's something that the board would be concerned about, and if it recurs, the board may ask for a greater sanction for that same conduct. And then you'll see the different suspensions that were imposed and the public reprimands that were imposed. We had a number of cases that were closed without adjudication for one reason or another. Sometimes we have investigations that are duplicative, or sometimes we have investigations where an attorney dies or something like that. So we had some that were closed. Dismissed means that we got to the merits. Closed without adjudication is that we didn't get to the merits, that there was some other reason to close it. Sometimes there's a suspension that's imposed for a lawyer, or the lawyer goes into retirement and we may decide internally that for case processing reasons we want to close certain matters without adjudication. Kind of just depends a little bit on what we're dealing with that lawyer's circumstances. But if it's dismissed, it means it was reviewed and a determination was made either that we couldn't prove an ethics violation or there wasn't an ethics violation, kind of one or the other. Sometimes we have proof problems just like any prosecutor's office, and sometimes there really was nothing wrong at all. One of the things that's a little frustrating, I didn't really talk about this directly before, but one of the things that's a little frustrating to practitioners is that if the allegation that the complainant is making is something that, were it true, it would be an ethics violation, I have to open it. So sometimes we'll get a response back from an attorney that essentially refutes everything very clearly and very persuasively that the complainant said, but that investigation had to happen anyway because the allegation, if it were true, would amount to misconduct. The most frequent allegation that we see is probably no surprise to any of you. It's neglect and incompetence. My lawyer didn't pay enough attention to me, or my lawyer is dumb. I mean, really, like, I see that. My lawyer is stupid. You know, and I'm not going to open my lawyer is stupid, but I'm going to have to open my lawyer didn't respond to my phone calls, or I sent a bunch of letters and my lawyer didn't communicate with me, or my lawyer failed to notify me of a hearing or something like that. Those we do have to open. The next highest number of complaints, and these, if you take all of these and a number of other allegations that I didn't even include on here, they add up to way more than 100%, and that's because sometimes people allege more than one thing in a complaint, and I tally more than one thing when those complaints come in. So you might get a neglect plus a dishonesty allegation, and I would log both of those. About a third of complaints include an allegation of dishonesty or misrepresentation. That is not something that gets proved very often, though. A lot of times people will say that their lawyer lied to them about the impact of a plea agreement, or a lawyer lied to them about the likely outcome of a particular stipulated disposition or something like that. But very often the lawyer is able to refute that. So we don't have a third of our respondent lawyers lying to everybody. I think it's just that that's a pretty common allegation that we see. One of the allegations that I think is kind of interesting, people allege conflict of interest a lot. I try really hard to capture only ones that truly would be a conflict of interest. It isn't, in my opinion, a conflict of interest if you know other people involved in the case. It isn't a conflict of interest if you shook hands with the opposing attorney on the way out of the courtroom. It isn't a conflict of interest if the judge knows your name. It isn't a conflict of interest if the judge goes to church with you. You know, I mean, we get a lot of those types of allegations where the public doesn't really understand necessarily what the conflict of interest rules provide. And for them, it's, oh, there's a conflict of interest because you all know each other. But that does tell me something about the perception that litigants have about our process and how important it might be to remind your client that while you're going to be civil with and perhaps greet the judge and opposing counsel, that doesn't mean that you're not on their side anymore. It just means that you know these people and you work with them professionally, and you might even know them personally, but it doesn't mean you don't want to beat them. It doesn't mean you don't want to win when you go to court. So that's just something that I hear a lot from complainants, and I think it's something that we could very easily and proactively address. So give your clients that heads up that you're going to be nice to people, and that's okay. And you may even shake hands with opposing counsel at the end of a hearing, and that doesn't mean that you just made a deal to sell them out. That just means that you're being professional because this is a professional setting. Some of the things that I'm working on for this year, just so you all know, we're working very hard on making sure that every complaint gets a timely response. And if the response is not forthcoming within the time that's provided by rule, we're asking the court to suspend that lawyer's license. That's been working real well. We've had to chase far fewer responses than we used to. We have a really great case management system in place now, so I'm able to identify those cases where we're expecting a response and haven't yet received one, and that's been great. And again, that's a way of keeping things moving through our office so that we can get them done. We're working really hard, like I said before, on reducing investigative times, and on matters that need to be prosecuted, we're working on reducing the time to filing that complaint to get the matter prosecuted before the Grievance Commission. So we're trying to just kind of get this going as quickly as possible, again, because I know it's disruptive for people's practices to have to respond to these and then worry about them. And it's also, you know, it really doesn't serve the public interest. Part of what we're charged with, of course, is protecting the public, and if it takes us 8 or 10 or 12 months to get to an investigation, are we really protecting the public in the interim? So we're working hard on all of that. So that's phase one of what I wanted to talk with you about today. Phase two is how do you avoid running into these ethics problems? And I have spent a lot of time thinking about this. As I said, I've read now many hundreds of complaints. There was a big stack even on my desk as I left just now. I had like 3 that I didn't get done today. And I think I've come up with some general pieces of advice that can help you to avoid getting a complaint sent in the first place. I think it boils down to 2 things. I'm really only going to talk about thing 2 here, but I did include in the materials that I submitted for this talk some information about managing your client's money, because I do think that those trust account rules are really, really essential to good practice. And so I'm going to blow through these slides real fast, but I think that that is really, really important, and so does our court. Our court has said that the business side of your law practice is absolutely as important as the rest of your practice of law, and I couldn't agree more. And I see people run afoul of these rules, oftentimes inadvertently, not because they're necessarily stealing client money, but they're certainly making it look like they're stealing client money. And then we have to figure out whether they were actually stealing client money. You don't want to be that person. No, go ahead. Well, because they're maybe not giving clients notice when they're withdrawing from their trust account against outstanding bills. So then you don't really know, did they earn those funds? How did they earn those funds? They're not providing billing statements. You know, you're required to put every penny of client money that you receive that isn't earned in your trust account. And so all of those funds, all of those unearned funds that belong to your client, regardless of how much they are, need to go in the trust account. People who don't do that are creating situations where it looks like they've taken that money when it really still should belong to the client. The bottom line with this, and like I said, I don't want to spend a lot of time on it, but the bottom line is that the money in your trust account belongs to your client. And it still belongs to your client until you do something. And the doing something means you have to earn it, and you have to tell them that you've earned it and you're taking it. And once you've done those things, then the money becomes yours. Yeah. Exactly, exactly. And that's the problem. You know, if you're loosey-goosey with your books, it's not that you're necessarily doing anything nefarious, but it can start looking nefarious. And so if you're not really comfortable with trust accounting, I encourage you, go to some CLEs about it. I know my colleague Trinity Brown-Arana has been doing a number of client security types of CLEs. I think she's scheduled to do one at the next annual meeting. I believe she's scheduled to do one at the next ISBA annual meeting. But she will also just talk to you on the phone and tell you how to do it. You know, the auditors who come visit your office are also a great resource for making sure that you're doing this stuff right. They're not there to scuttle your practice. They're there to make sure you're doing it correctly, and they will give you great advice. And then, of course, there are all sorts of great case management and financial software systems that can help you with this too. So if you feel like you're struggling with trust accounting, please reach out and ask for some help with it. It's something that I think we can rectify very readily. And like I said, you'll then avoid the appearance of doing something wrong, because we can't tell if we don't know where the money's going and why it's going anywhere. We can't tell if you're taking it because you're stealing it or you're taking it because you're entitled to take it and have earned it but have just not complied with the rules. So, second thing, and the other secret to avoiding ethics complaints, in my opinion, is to manage your client's expectations. And I think these unmet expectations complaints are really, they're probably 2/3 of the complaints that I review in the office. And there's certainly a significant percentage of the ones that I end up having to open. These are clients who say they thought they were going to talk to you more often. They thought they were going to win their case. They thought that they were going to have a trial and get to see a judge. They thought that they were going to get whatever disposition someone else they know got. They thought they weren't going to prison. They thought they were going to get another chance. They've been in trouble before, or they've had this circumstance arise before. It's a juvenile case. They thought they were going to get more time. So think about that. What are their expectations coming into their interactions with you? And are you meeting those expectations or helping them to adjust those expectations? And the reason I think this is especially important for those of you who do the kind of work that you all do, and I come from a family law practice background, so I did a lot of the same kind of work. We spend a lot of time, well, I can ask you all, who here has had to give bad news to a client in the past month? Hands up. Who here hasn't had to give bad news to a client? I want to know who you are. We do that, right? We have to give bad news to people. We tell them all the time things that they would prefer not to hear. Right? And what's their response going to be when they hear something they prefer not to hear? The messenger must be wrong. You can't be right about that. You must be lazy. You must have not been working hard enough. You're working the other side. You're selling me out. You didn't really want me to win anyway. I got one of those just today. I got a complaint alleging that today. I've never read the word cahoots as many times as I've read it since I've been reading disciplinary complaints, but man, y'all are in cahoots with everyone. Yeah, exactly. Shh, it's a secret. But that, again, that's that perception that if you were good, if you were doing it right, they wouldn't have to hear any bad news from you. So this was my starting point in practice. And I think that it works really well, and I suspect many of you do this. You tell your client repeatedly, as often as you can tell them, I am on your side. I am your advocate. I am here for you. I am here to help you navigate this very complicated system. I really like to win. I really, really love getting it right. I think it's really cool when I beat Mark Goldberding. I don't know if I ever did, though. But we like to win, right? Why do we go to law school? We like to be on the right side of these cases. But I will also be straight with you. And if I don't think that that's going to happen, I am not going to lie to you about it. And your clients, if they hear that from you and they internalize that, I think I will hear far fewer complaints about lawyers. And I think that there are 2 slides that I put in your materials that I'd like you to take a look at. Yeah, go ahead.
Law school to get in cahoots with people.
Absolutely. Well, and apparently we have all succeeded because the clients are pretty sure we're doing that. I put a couple slides in your materials that I think are really great. Medical professionals get all sorts of training in how to break bad news to people. If I am a doctor, I'm an oncologist, I have to give people terrible diagnosis information all the time. And they teach whole classes in med school about how to do that. There's a whole literature about this. We don't have any such thing in our practice, and we've got to figure it out on our own. And I think that that's a sad reality for many of us. We spend a lot of time trying to share bad news with people, and we don't know how to do it. So these medical models, if you just Google search Breaking Bad News Doctor or BBN Doctor, you'll find this stuff. It's great. They give you all kinds of advice about how to frame that interaction with a client, or a patient, how to talk to them about their circumstances and how your expertise can guide them through this really scary time. One of the things that is almost always advised in both that Spikes model on the last slide and this ABCDE model is that there needs to be a lot of time during your interactions with clients when you stop talking. And we suck at this. I mean, we're really not good at this, right? I think every lawyer in this room can probably fill a good lot of silences. And we also, I think, get a little uncomfortable allowing a silence to persist for very long because we feel like we should be filling the client in. We should be telling them what's going to happen. We should be advising and all of that. I think it's really important when you are sharing negative assessments of someone's case with them or bad news about what's already happened. So either bad news you're anticipating or bad news that has happened already. Give them some time and say it out loud. I'm probably giving you a lot to digest here, and probably some of it is stuff you don't want to hear. Why don't you think for a few minutes? Go get a drink of water, come back. Give them a few minutes to process what you're telling them. Think about this like you are giving someone a cancer diagnosis. That's big, scary stuff, and you want to give them some time for their brain to catch up with the words that you've told them. So I encourage you to include some silences in your communications with your clients, and then recognize that during those silences, they may be processing a lot of feelings and a lot of emotions. They may also be misunderstanding you. And so you can, at the end of those silences, ask them to tell you what they understand about what you just told them. And sort it out then on the front end, rather than having to deal with it later when they said, no, you told me that I was going to get better, I was going to get a good outcome, everything was going to be fine. I kind of boil this down into a bunch of pieces of advice here. One, talk to your client about how frequently they're going to hear from you. Tell them how often they're going to hear from you, and then do it. I think I had 3 complaints today that involved allegations that an attorney told a client that they were going to visit them in jail or prison and didn't. Said they were going to come next week, next month, and just didn't. I have to open that, because if that's true, that's an ethics violation. And oftentimes it is true, not because the attorney has any bad intentions, but because the attorney gets busy. So make sure that you realize that you are setting expectations for clients when you tell them that. And when those expectations are violated, they're going to be unhappy. For cases where you have a fee agreement, not appointments, obviously, but for other cases, make sure you have a clear written fee agreement. I promise you, it will save you so much trouble when responding to a disciplinary complaint. Oftentimes, we don't typically handle just straight up fee disputes, but oftentimes there are fee issues embedded in a complaint. And I believe that, and you probably all would agree with me, that sometimes that's the driver of the complaint. They got the bill, they're unhappy now. But we may have to open the complaint because there are other allegations made. So have a clear fee agreement and do straight, easy to understand billing. If you do descriptives in your billing, don't just do attention to file, but write down what happened, note what happened, so that you're justifying the work that you did. Talk to your clients, and I think this is especially important for people who are dealing with juvenile cases or family law cases or criminal defense cases. Talk about your boundaries and your limits. When are you going to be available? We'll talk in a minute about one. I'm not allowed by court rule to give you advice, but I'm going to break that court rule and give you a piece of advice a couple of times during this presentation. I don't believe that you can practice law by text message, and so I really discourage people from, unless your cell phone is your only way of communicating with clients, don't provide that information unless you're willing to answer it all weekend and every evening and any other time. You need to frame those expectations with your clients so they know how they can reach you and how often they can get in touch with you. And then I encourage every attorney to give your client a notebook. Make it pretty if you want to. You can put a sticker on it with your name and your law office phone number and all that. But give them a notebook and encourage them to write things down that they want to talk with you about. Again, it's the advice we all get about going to the doctor, right? You're working on some sort of complicated medical problem with your doctor, and your doctor is going to say, did you write down all your questions? Write down all your questions for me. So do that. Give them a nice notebook and say, hey, I'm so glad that you called me at 4:45 on a Friday afternoon to tell me about your problematic visitation exchange. Why don't you write that down? We'll make an appointment for next week. And then you're not dismissing them. You're acknowledging that those are important questions, but you're just framing when you can handle them with them. Talk to your clients about their goals. Again, as part of setting expectations, you should say, what are your goals? If you're telling somebody bad medical news, you've got a scary diagnosis, what are your goals? Quality of life, length of life, what are your goals? I want to be able to travel someplace I've never traveled before. Okay, how are we going to make you well enough to do that? Those are reasonable things for a doctor to ask. We should be asking those questions too. What are your goals? And then, like I said, lay careful groundwork for any bad news that you have to deliver. Bottom line, I think that we can meet our client expectations, and I think the way we do that is not by selling our souls or working all weekend every weekend and all night every night, but instead manage your client's expectations so that you do meet them. And then tell them when you've met their expectations. Hey, we set a goal of this and we got that. You know, you wanted this kind of contact with your child. Well, we were able to accomplish that. Heck, write them a letter and tell them that you accomplished the thing that they had as a goal. Those sorts of things are, I think, really, really good for you professionally. I think that they'll create better working relationships with your clients, and they certainly will, I think, avoid the types of problems that give rise to complaints that I see. Third part of the presentation. There's like no transition here at all. You asked me to talk about media issues and social media and blogging and review sites and all of that. And so here we are. This is actually new-ish stuff to me. And the reason that many of you know that I come from a background outside of lawyer discipline. This isn't what I've been doing for my whole professional career. I did family law practice. I ran Story County Legal Aid for a while. I didn't come from this area. But it wouldn't have mattered if I had, because this is brand new to all of us. My colleagues who've been in lawyer discipline for 40 years are just as stymied by this as I am. We're all learning it together. We're all trying to figure out how to cope with this evolving new landscape, this place where so many of us spend so much of our time. So what I'm going to give you is literally up to the moment, like as of yesterday, information, with the caveat that it could all change tomorrow, because I don't really know. So here's what the internet is for, right? Memes, all the memes. This is what it's for. This is what we do on the internet. We look at Facebook and we look at memes. And we look at videos, goofy videos of people. That's what we do on the internet, right? I kind of like the grandparent cats ones, because that's what it looks like when I Skype with my in-laws. It's kind of awesome, except usually they're backlit because they've like put it right in front of a window. So then you've just got these sort of backlit shapes Skyping with us. This is also what the internet is for. This is yesterday. Many of you probably saw this story. My colleagues in the Utah State Bar sent out an invitation to their annual CLE meeting to their entire membership. I believe is about 11,000 lawyers. And the photograph that was attached to that email was of a topless woman. So what the internet is for everyone to laugh at stories, right? We all read this story and we go, oh my gosh, and everybody's tweeting about it and everybody's more clever than the last one. And this becomes this huge news story for my poor colleagues in Utah. Utah's bar also does their discipline. I don't think that their bar does the invitations for CLE, so my direct colleagues are probably not connected with this. But anyway, so the internet blows up for a day about whatever the story du jour is. Areas of concern for me in attorney discipline include a whole bunch of different things, and I sort of made a list as I was putting this material together. Sharing information about cases, dealing with online reviews, friending people, following people, your clients, your judges, opposing attorneys. What counts as advertising in this new world we all live in? Is your Facebook page, your law firm Facebook page, an advertisement? What does it have to look like? There's important information out there, again, really evolving very rapidly about how to get and protect electronically stored information, stuff that is contained in our phones and our tablets and our computers. And then also, as I said before, practicing law via text message, which I will again break the rule and tell you, please don't do that. It's a bad idea. You can't text and you can't be a lawyer by text. And I'll give you an example in a few minutes. Confidentiality issues really kind of are the overarching concern here. And the thing that I wanted to point out to all of you and remind you of is that our disciplinary rule 1.6, which deals with confidentiality, is much broader than the attorney-client privilege that you might assert. Client confidentiality obligations, your duty of confidentiality, really extends to everything to do with your representation. The names of your clients, absolutely everything that has to do with that representation. And if that information is made public by some other means, it becomes a news story, it becomes somebody's Facebook post or their Instagram picture, you still can't talk about it. That duty of confidentiality does not go away, even when people can learn about that information from something else. Hint, court order. Even if it's a court order, you don't have the right under the rule to disseminate that information yourself, even if it's publicly available. So that duty of confidentiality is so central to what we all do. There's a really great American Bar Association formal opinion that came out 2 days ago about confidentiality obligations if you are going to be putting any sort of case-related information on the internet. And I encourage you to take a look at it because I think it really does reflect the most current thinking about the way this rule applies to the things that people do online. One of the things that they very clearly say is that you cannot cloak your disclosure of information behind the label hypothetical if it's likely, reasonably likely, that a third person could figure out who you're talking about. So, you know, people try to be super clever with their Facebook posts about the case that they're trying or the information that they've learned about another party or whatever. Be very cautious, because if people can figure that out, and oftentimes they can, you could end up having breached that duty of confidentiality. Number of people who've been, and we don't have a lot of cases like this here in our state, so I don't want to freak you all out and have you think that everybody's out there blogging about all their cases. This happens more in some bigger cities. It happens more in some higher profile cases, but it does happen here from time to time. Keep in mind that your claim of your First Amendment right to speak is really secondary to this obligation. We give up some of our rights to speak as much as we want about whatever we want when we take on a representation. So those First Amendment arguments tend not to go very far when there's a claim that somebody has breached their duty of confidentiality. I came across an interesting Washington, D.C. ethics opinion that I thought I would at least bring to your attention. Be careful about letting your social media sites access all of your contacts. A lot of social media sites, LinkedIn, Facebook, whatever, will say, you know, hey, do you want me to search through all your friends and figure out who your other likely friends are? Keep in mind that Instagram doesn't know if you're my friend or my client, my real life friend or my client. So be cautious about that, because that information really is properly under the umbrella of confidential information. It's not something that should be shared. So keep that in mind. A lot of us keep our client phone numbers in our address book, you know, a Google address book or whatever. So just be thoughtful about that. Yeah. They do. They love it. Mm-hmm. And some practitioners do. That's how you work. They can reference the date of the hearing, for example, and the time where they set the envelope down in their car and then right. Or they never opened it. Yeah. Right. Yep. My husband was super malpractice as a doctor, and every time he got an envelope from his attorney, he wanted to vomit. Yep. So, I mean, I try not to overmail them, and I always notify them, like when an important order is issued via text message, so they know right away. Like, yeah. Well, and they don't listen to voicemails. And they don't listen to voicemails. Most young people these days don't email. So you're right. I mean, this is a little bit of a conundrum for us.
But what's the concern? Are you saying where attorneys are reducing their contact to basically discussing things via text?
Yes.
They don't have the
Yes.
conversations and meetings anymore?
I think that's really the concern. I think that particularly because, again, I think that's what our clients want. They conduct their entire lives. They conduct romantic relationships by text message. So just be thoughtful about that. If you do share that information, I think that what you're describing is the kind of use of text messaging that makes sense. Hey, don't forget we have a hearing tomorrow. You need to wear nice clothes. You know, I'm running late for our appointment. You know, we were going to meet at the coffee shop. I'm running late. Those types of things. But when it comes to the content of your legal advice, of your assessment of their legal situation, be really careful that you're not practicing law by text message. You're managing an attorney-client relationship maybe, but not necessarily practicing law. Yeah, Barb?
This all came up because I went to the seminar last fall, and as you looked through this, am I incorrect that there's a rule that any communication that you have with your client through that electronic form, like the text, you have to keep a copy of it in your records? Did you find that as you were going through things? Because that's how I understood them telling us that that was the concern about having those electronic communications to keep a record of it.
I understand that to be a concern, and I agree that that's a concern. I didn't find any disciplinary decisions that faulted a lawyer for failing to do that. Certainly, that's the most self-protective decision you could make. And I will tell you that a significant, we'll get to this in a moment too, but a significant number of complaints coming into my office are accompanied by printed out text message communications between attorneys and clients. They're perfectly happy to screenshot those and send them in and tell me, you know, what a terrible job somebody did. So just be thoughtful about that. I think for your own protection, it's right. You know, you're right. You should consider keeping copies of that, screenshotting that stuff yourself. And again, you know, you're kind of spreading the information about your representation out in a bunch of different places then. It's really hard to even figure out at that point what the timeline of your interactions with your client was. So that's important too. Yeah.
But whatever the negative potential is, you know, potentially, theoretically, for example, deception or whatever, we're supposed to warn them and get consent, all that stuff. But nonetheless, you still have proof that you sent an email, for example.
Yep.
As opposed to if you send them something certified, they might be too lazy to
They won't go get it.
Mm-hmm. So the electronic communication does have some advantage in terms of documenting should they turn around.
I totally
start
agree.
making these stupid allegations against you.
And as long as your client, you know, as long as you work out with your client what they should expect from you in the way of communication, and then you follow through, I think that's really central. You know, if they agree that they're willing to communicate with you by email, then do that. And then you've got a good record. My advice is to save the texting for short procedural things rather than for legal advice and content. I'll get back to that in a minute too. I wanted to talk to you too about sanitizing your social media and also preserving social media, kind of two sides of this. Florida has an ethics opinion that allows a lawyer to advise their client to sanitize their social media accounts or tighten up their privacy settings as long as nothing gets destroyed permanently. There have been a couple of jurisdictions that have sanctioned lawyers for advising people to, obviously, I mean, you've got evidentiary concerns if you advise somebody to discard their whole social media site, or failing to take actions to preserve it. So sometimes clients will disable Facebook, but it's still there. Just be very cautious about anything your client might interpret as advice to delete all of that stuff, because that is potentially discoverable material. Many practitioners, though, I think without any problem, advise people to stop putting new stuff on social media at the beginning of representation. I know in my practice in family law, I used to routinely advise people, you know, hey, your case is your business, so why don't you keep it your business while we're working on it? And some of them would take that advice and some of them wouldn't. Generally, social media content is discoverable, and there are kind of jurisdictional differences, and I'm sure even within Iowa, if you guys were to talk about cases where social media issues have come up, you'd probably find that judges handle these on very much an ad hoc basis. It's probably different day to day, judge to judge. But generally, social media content is discoverable even if somebody has set their privacy settings to very high. Most courts have said that you can't have a reasonable expectation of privacy for information that you put out on the internet, even if you make it available only to a fairly limited group of people. In contrast to that, though, most courts won't just say, many courts will not allow you to just demand of the other side their password and unfettered access to their whole social media profile. So that's really going to differ depending on the case and depending on the jurisdiction, and like I said, potentially depending on the day and the judge and what the judge has recently, you know, kind of come to understand or hear about different types of social media platforms. Most of the information that I've been able to glean suggests, and you all probably know this too, that subpoenas to social media providers don't get you anywhere. You're not going to get Google to be like, sure, I'll cough up all that stuff. They got bigger things. They've got to fight with, you know, the federal government about that. They probably don't care very much about your little case. You might consider, and a lot of attorneys do this, a preservation letter directed to the opposing party or counsel, just indicating to them that they should not destroy any of that information, that they need to preserve it and protect it during the litigation. And some people also recommend that you consider requests for admissions to authenticate social media posts. And I've never used it, never used a request for admissions in that way, but you know, if it'd save you some time, you could attach a post and say, admit that you posted this or wrote this. So think a little bit about the value of those, and think a little bit too about how you can make sure that they remain available, both for the other side to discover should they want to, and for you to obtain from your opponent. Side note, this is brand new stuff. I think it's really important. Who here has traveled internationally in the past few years? Okay. When you take your phone or your tablet or your computer across an international border, Customs and Border Protection has incredibly broad discretion to review whatever is on it. They can make you give them they can request that you give them your password, or use your thumb or whatever. They can request that you leave the phone with them. They can review pretty much anything they want to on people's devices as they're crossing international borders. This was something that a lot of attorneys, particularly immigration attorneys, got very worried about. It would probably not be very helpful for their clients, for Customs and Border Protection, to suddenly know who all those people are and what their circumstances are and what types of filings they've had and so forth. So I encourage you to go read, January 4th of this year, Customs and Border Protection issued a directive. And I encourage you, if you are doing any international travel, this is me in a few weeks too, so I'm thinking about this as well. Read this directive and just think about what you can do to, I'm just going to use the word that I just said you shouldn't use before, but to sanitize your devices before you go. A lot of people recommend that you put everything in, rather than having it in the phone, on the phone, you put it in the cloud. They are less able to access things that are in the cloud than they are things that are on the memory of the phone. The other thing that this directive talks about is that you should inform Customs and Border Protection that you are an attorney and that you have privileged information in your device. So if you're doing any international travel, just keep this in mind. We have a lot of sensitive information, and that duty of confidentiality is going to come up against your interest in not ending up detained at borders for lengthy periods of time. So just keep that in mind. That directive is widely available, and you can just go search for it. It's from January 4th of this year. Yeah.
What are there border people? Sorry. Thank you. What do the border control people in other countries think of all this? Not, although I don't think it's necessarily terribly relevant to, our situation. Whatever happens to our clients, unless, certain
I don't know.
exceptions, yeah.
I haven't really heard anything about how other countries are handling that. Obviously, there are countries that there are various State Department warnings about, and so you should be cautious about taking information to those countries, but I don't know. I wouldn't be able, I just want to make sure that if you are taking your client's information across a US border, you know that they can look into a lot of things. And your position as an attorney gives you a little bit of ability to push back, but read that directive if you're doing any traveling and just think about it. Think about what you don't need to take with you. I just went to Canada. I took my cell phone. I don't have client information on it, and I really don't have respondent information on it. The only thing it does is fetch my emails, so I can disable that. But just think about it if you're doing that kind of travel, because we just live out of these devices, and I know many of you probably have lots of client information in your phones and tablets and computers. Texting. I said I was going to get back to texting. This is a recent Nebraska case. Well, last year, about this time last year. A Nebraska lawyer received a 90-day suspension because he essentially spent 4 years working with his client through Facebook Messenger, saying things like, chill out, I got this, and I'll figure this out later, and I don't have time to talk to you right now, and we won. That's what I'm worried about. You need to make sure that your client is getting content from you somewhere. Yeah. I don't believe so, but I don't recall. I'm pretty sure that the complaint came in because the client was unhappy. Now, there were some other issues, so there were some other violations rolled in, but this got everyone's attention because I do see exchanges between lawyers and clients that look a lot like that when the clients send them in. So just be aware of that they might be really happy to run their relationship with you through Facebook Messenger or text message until they become unhappy with you. Here's another media-related thing. Oh, I'm sorry, go ahead.
But if you have some of that kind of communication via, text, email, whatever, more as the means to create a placeholder. I don't have time to deal with this right now, but we will meet
But then you have a file, or you have an email message, or you have other things.
Or I have a documented call or whatever.
Yes,
okay, all right, and that's
different. Yeah, that's the thing. That was the extent of this lawyer's communication with this client for almost 4 years. So yeah, think again, like I said before, it's kind of like what makes up the entirety of your communications with your client. Some in-person meetings, some telephone calls, some text messages maybe, some emails, all of those things together. But just be cautious. There are a number of complaints that we get where it looks like that's all that happens. Hey, can I get an update on my case? No, don't have time right now. Hey, I'm still waiting for an update on my case. Don't have time right now. Then it's pretty clear nothing happened in the interim. Yeah.
I'm just wondering if other attorneys are experiencing this. I've been doing this for 35 years, and I am now experiencing clients who, when I say, I would want you to come in and meet so we can go over what we are doing, they're saying, no, I don't have time. You're just trying to charge me more money, having me cut.
Yes.
So is this a generational thing that is coming in that we're having? We can't. It's like, I want to see you. You have to talk to me. And that client, I finally said, well, obviously, we're not working well together.
We're not the right ones for each other.
Knock yourself out. Go find someone else.
Time to break up by text message.
So I mean, is that what we're seeing? Is they don't want to come in and do these face-to-face things?
That would be my interpretation. I mean, we're dealing with, and I didn't even touch on this in the materials, but we're also dealing with a highly competitive legal market right now where people believe they can get legal advice from other places, Avo, other types of providers. And so I think you're right. I think that they're worried about the cost of that FaceTime with you, real FaceTime, not FaceTime on the phone. But, just be aware that when the relationship goes sour, suddenly it wasn't enough for them. It was enough for them when they didn't want to pay you any money, but just be careful about that. This is an interesting case out of Louisiana. My colleague Tammy did this. This is a lawyer who got really, really enmeshed in her friend's custody dispute. She wasn't counsel. She was just really, she cared a lot about these kids and decided to start a change.org petition to the court. So she created this viral marketing campaign, essentially, to try to influence the decision-making of the judges, which was a bad call. There was some dispute about what the proper disposition of this case was, and in fact, the court ended up doing more than I think counsel for the bar asked for, and disbarred the attorney. But this is what happens. You know, we all live our lives kind of out in this open forum now. And people may believe that they have a First Amendment right to go advocate whatever they want, but you want to be really cautious about this type of engagement. I mean, obviously, this person wasn't able to detach herself from her friend's case, and it's terribly sad. I mean, I'm sure that you know, she put a lot of time and effort into getting that law degree, and I think had a lengthy. I believe she had a lengthy practice, but got so enmeshed in this case that her judgment just went out the window, and she decided that she should start a petition. Online review sites. Many of you are probably familiar with these now. This is Yelp Reviews. It's Google Plus Reviews. It's Avo. It's all of those. It's Facebook Reviews. One of the issues that's come up for a number of disciplinary offices is whether or not you can offer a client money to review you. The consensus seems to be that you cannot. We don't have any decision on this in Iowa. I encourage you not to be my test case on this. I really don't want to take this one in front of the court. But the consensus seems to be no. New York has an ethics opinion. They have a slightly different rule than our rule, which is the model rule. They do have a case that says that you can give a $50 fee for someone who rates you online, or give them a $50 discount for someone who rates you online, but you can't control the content of the rating, obviously. But just, again, please don't do this. This just worries me so much. And I know that there are reviews out there, and they're frustrating, and they're scary. But my gosh, please don't be my first case on this. Second thing about online reviews that I've gotten asked a million times already is, can you respond when somebody bashes you online? And if you can, what do you say? And again, I'm going to frame this by reminding you that I can't give you advice, and then I might give you a little bit of suggestion here. As I said before, Yelp is a big source of these reviews. Facebook, Google, Avo, all of that. 4 years ago now, Yelp was the most popular site. And this survey was interesting. 70% of clients who were looking for a lawyer said that they would travel further to see a lawyer who had better reviews online. More clients looked at the internet for recommendations for lawyers than asked family members or friends for recommendations for lawyers. And so most marketing pros say you should claim your profiles, partly just to make sure nobody else claims them. You should claim those profiles, and then you know, at least you know what's there for you. Don't, under any circumstances, put up a bunch of fake reviews, please. This isn't like Amazon. Don't tell all your friends to review your great new book. Be really careful about that. We've seen a few cases already with attorneys who do that. So be careful about that. And as far as negative reviews, which do happen, most experts say that you shouldn't respond at all. And I know that that is very frustrating when someone has impugned your reputation, they've said nasty things about you. I know that's very frustrating, but I encourage you to think long and hard before you post any sort of response, because that confidentiality obligation is really easy to mess up. You know, if somebody says, I hired you for my divorce and you were terrible and I lost and you were awful, and then you write back and say, well, your facts were terrible, and by the way, you were, you know, and don't do that. Don't. That's just a bad idea. Avo has a suggested response, and I can't endorse it or tell you that it's bad or good, or I don't know. But I think it maybe hits on kind of the right note, which is, I'm sorry you had a bad experience. This doesn't sound familiar to me, but I encourage you to contact my office. So there you're not disclosing anything. You're just saying, you know, I work hard for every client. I'm sorry that you feel that you may have had a bad experience. I'm not familiar with your matter. Please contact my office. There are disciplinary cases in a number of states that have imposed, where the court has imposed sanctions on lawyers for responding to online reviews for, again, these violations of confidentiality and loyalty to their former clients. We've seen some reprimands, we've seen some suspensions. You know, we're all over the map in terms of disciplinary sanctions nationally, but people are getting in trouble for this. And then there are a couple of ethics opinions in West Virginia and in Texas that have specifically said that your self-defense exception that allows you to violate your duty of confidentiality or go outside your duty of confidentiality to deal with ethics complaints or disciplinary matters does not apply in this situation. So you don't get to just put it all out there because somebody has said something negative about you. Couple of last things. Friending. You can't, Ohio had a case where an attorney created a fictitious Facebook identity in order to engage with a potential witness in a murder case. The court determined that that was unethical. There is no public policy exception there that would get those prosecutors out of the duty of honesty, even if they had great intentions, even if they were trying to help, you know, get a case prosecuted. So be really careful about your obligation to be truthful and honest in who you are, you know, about who you are, and don't create a fake Facebook profile. And then there was a recent-ish, couple of years ago, New Mexico case where we had a judge that had friended some people. The court didn't want to put in place a ban on judges being friends online with people, and actually specifically said that in this current climate, we now understand that being a friend of somebody on a social media site does not imply or does not necessarily denote a real world friendship with that person, that's just a way that people kind of have professional connections or acquaintance connections. I think that's kind of where the thinking seems to have gone on that. Maybe when we all started out on Facebook, they were people we really knew, but now they're not. And anyway, Facebook's not cool anymore. So if you're not on Instagram, you're nobody. For the next 5 minutes. Last thing I want to mention about media things, be very careful if you are a prolific blogger or tweeter about things you care about in the world. This was an interesting ethics opinion that came out of Washington, D.C., probably not surprisingly. If you do a lot of writing online about particular issues and you establish a firmly held strong position as yourself, not as a lawyer, but as yourself, be very careful that you haven't created what's called a positional conflict between you and your ability to represent clients who want to assert the opposite position. So, you know, if you get out there online and you're really charging ahead with some particular belief that you have, and then you're going to end up in court trying to advocate for the opposite or a different belief, you may create a conflict for yourself. So just be thoughtful about that. I don't know if any of you are big bloggers. I don't know if anybody blogs anymore, but something to keep in mind. Finally, the last thing I always end every presentation with is a reminder that we are only as strong as a profession as our weakest member. We have a really big problem right now in our profession with mental health and substance abuse issues. Look out for each other. If you've got a colleague who you think is struggling, reach out to them, remind them that the Iowa Lawyer Assistance Program is always available. Hugh Grady is willing to drive all over the state and do just about anything to try and get people help. That applies to both substance abuse and alcohol problems, mental health problems, the stress of dealing with a disciplinary complaint, situational stress, you name it. He and his group of folks will reach out and help. They do not funnel information to me. I don't know what's going on with them. I know they're doing great work, but I don't know any details. So if you ask for help, that's between you and them. And I encourage you to make sure that if you need help or if your colleagues need help, that you get in front of that, because we all have really important licenses to protect. So that's it for me.